Welcome, everyone. The time being 9:40, we will get started on the public hearing for SB 112 FN, amendment number 2023-2358H. And I guess we'd probably start with Representative Doucette. Do you want to introduce the amendment?
Sure. Thank you, Mr. Chairman. As we looked at this at our last meeting, what in effect this amendment does is it puts a moratorium on expanded HHR and eliminates the charge of rent for the charities to participate in charitable gaming. That's kind of it in a nutshell. I think we've all heard testimony, and some of us on the committee are involved with the Charitable Gaming Commission. Rent has been an issue for not only the charities, but those of us who recognize it's long past its time. We've heard testimony that this was the rent component was going back to inception of charitable gaming. Some people reference the nights of casino nights and church basements to make the ends meet for those folks that were operating those. And obviously, with the advent of the model we have now and the expansion of that model, this is long overdue, eliminating this rent component. Secondarily to that, the moratorium on the HHR machine. I think we can all attest to the fact, and I know specifically in my town, the people I represent in Salem, right now I believe we have 14 or 15 charitable gaming establishments in the state of New Hampshire, which far exceeds the totality of New England. I think we have a phenomenal model that benefits our charities, but I think we've all witnessed what's transpired since the advent of the HHR component, that one singular game, with larger operations coming in, buying up rooms, taking over the space from the local operators. There's been great interest in my town of Salem. And you've heard me say it before. I think now is the time to put the brakes on this. I don't want to particularly turn Salem into Atlantic City. You've heard me say that time and time again. These operators are really pushing for this. You can just look at the expansion of, for instance, any of the border towns, but the Nashua, one particular room has expanded. We don't need to list them all. There's great benefit to the model, to charities, to the state, and to the operators themselves. But I think we need to reel in what can get out of hand relatively quick with this component. This does not negate anybody from applying for and receiving a charitable gaming operator's license. And as an example, in the last I looked, last 5 years of that I looked into it back a little while ago, there had been no new applicants for charitable gaming operators licenses in the last few months. There's been, I believe, Director McIntyre testified to 4. I'm hearing rumors there may be 5 in the last few months, and my opinion is that's a direct component of the HHR game. And I just hate to see us change the face of what the model we have in the state is. So I would ask for support on Amendment 2358, and I do have an amendment to that in the component. You'll also have in front of you. I have an updated, more of a friendly housekeeping amendment 2444H. I had missed Rick Newman had pointed out to me I had missed in 3 different paragraphs where rent was mentioned in the statute. So this corrects that. Other than that, there's no changes. This allows for the 4 current applicants to continue through the process with lottery and open up their operations if they're approved. So as it stands now, we have basically the possibility of 19 charitable gaming operations with HHR. So I submit that, you know, we need to put the brakes on this before it gets out of hand. Thank you, Mr. Chair.
Thank you. And if you would fill out a pink card later so we can have that for the records, that'd be great. Okay. I do have one pink card in front of me. I'll bring Rick Newman forward.
Thank you, Mr. Chairman. My name is Rick Newman. I'm representing the New Hampshire Charitable Gaming Operators Association. We are here today to support the proposed amendment to Senate Bill 112 and the other housekeeping parts that were originally in Senate Bill 112. I'll be very brief. It's first, I'll speak to the subject of rent. Representative Doucette touched on it. This amendment would prohibit the charging of rent to charities. We do support that. Rent was originally put into the statute went back in a time when the maximum bet was $2 in charity gaming, and it was very difficult for operators to even make ends meet at that level of revenue. Later, it was increased to $4, and then in 10, and now, of course, you folks have increased the maximum bet to $50, and we believe that it's no longer necessary that the rental charges be included, and this will benefit charities a great deal. There'll be a significant amount of additional revenue to each charity participating in games of chance. We also support the second part that is the major part of this bill, which is the essentially creating a permanent moratorium beyond those who have applied or in the pipeline now who might end up becoming qualified applicants. As Representative Doucette said, I've heard that it could be 3 or 4 potential applicants that are going through the process. Doesn't mean all of them will qualify. I don't know who they are, but it seems to me this is a reasonable approach to take to put so that we don't have on July 1 of 2024 under the current law the doors open up and we could have historic horse racing in every strip mall in every corner of the state. I don't think anybody thinks that's a good idea. Thank you, Mr. Chairman.
Thank you. Any questions? Representative Almy.
Thank you. I'll ask one of the ones I wanted to ask Representative Doucette on. This is something that's just been bothering me from the beginning. I haven't done anything about the rights of the licensee. Does charitable gaming in general have the right to kick people out?
Well, I think probably any business has the right to tell someone to leave the establishment. The
But
point,
it's specific.
yeah, this is getting specific because under current law, other parimutuel licensees, it is specific that you can tell someone to leave, and it's at the sole discretion of the operator. So that section simply adds historic horse racing to the section that allows that to happen at a simulcast facility.
Thank you. Even though it's different from a real horse racing place where people can get into brawls. But it just seemed there are places all over the country where, at least in the past, they have kicked people out because they had a camera with them. And I guess this allows them to do that.
Frankly, Representative, I don't think that's a big part of the bill. And if you wanted to remove it, you'd get no objection from us. I really do view that as a housekeeping section where HHR is parimutuel, simulcasting is parimutuel. It's just including it in the same language that covers simulcast.
Thank you. Not really.
Representative Notter.
Thank you, Mr. Chairman. The calendar note says that this hearing is for Amendment 2358H, but we're hearing about 2444H, is that correct?
So Representative Doucette introduced 2358, and 23444 is actually before you, just because he was pointing out a housekeeping change that we have to make to 2358. We were surprised when it came back from OLS, I believe, that it had a new number. We expected it to be 2358 with a slight, yes, Representative Doucette can
Yeah,
clarify.
it's basically, I missed 3 paragraphs where it mentioned rent. So we're hearing 5.8, and this is a friendly amendment we're gonna bring up after to include all the components that need to be covered.
Yes, follow up.
Well, I texted the clerk and I said, because I'm confused. And he said, if this number is not in the calendar, that we cannot have a hearing on it.
Okay.
And told
then
me to tell you.
Yes, Representative Ames.
Yeah, I understand the confusion. I did speak with the clerk actually on this bill, not this particular amendment, but the same issue. If this non-germane amendment is advertised, and then I or someone else comes in and wants to make a tweak or an amendment to that within the scope of the new non-germane amendment, we can do that. And so we're having the hearing, and Representative Doucette has recognized, as he's been looking at this thing, that there are a couple of changes that are within the scope. And actually, the word used by the clerk in talking with me is if there's a tweak, essentially that's what this is, meaning within the scope of the non-germane amendment that has now made this subject germane, it's okay. So we're discussing this bill that is tweaked that is going to be tweaked if we accept it by this non-germane amendment.
Yes, follow up.
May I just show you the text? Can I come over there to show you the text from the clerk?
Sure.
I think the question is where he's trying to put in the same germane to the non-germane amendment.
Mr. Chair,
Because we've always done this. Were these 3 paragraphs important?
Mr. Chairman,
Just,
if I may, it seems to me you're having a hearing on 2358, which was what was noticed. What I understand is that at some point there may be during your executive session, a friendly amendment offered to 2358. I believe under the rules that's permitted. That's just my opinion.
yes.
yes,
Representative Doucette.
and right or wrong, I just out of courtesy mentioned it during my testimony on 58. So
Okay, so this hearing is for 2358 only. Representative Doucette talked about what is in this other one, but we are not public hearing this. During exec session, we will bring it up. Thank you. And Representative Notter, does that answer your question? This is a public hearing on 2358 only. Okay. Representative Ellery.
Thank you, Mr. Chair. Just a question of Representative Doucette. The moratorium that you have in place, I heard the word permanent and I've heard the word temporary. Which is it?
thank you for the question. It is a permanent moratorium.
Follow up?
With a permanent moratorium, what does that do to a new charity that wants to get into charitable gaming and maybe include HHR. They're then barred from it, so they're at a disadvantage from any other charitable organization from engaging in that activity. Is that not correct?
If you pass this, that's correct. There would be a limit to the number of facilities that could have historic horse racing. There would not be a limit to the number of facilities that could offer table games and poker and other charitable gaming activities. Those would continue to be unlimited. But yes, it would limit to the current 14 and potentially the 4 additional applicants the ability to have historic horse racing.
Follow up, Mr. Chair?
Follow up?
So you've got these institutions that are holding charitable gaming, and some of them have HHR. Anyone who wants to put in a new gaming facility would then, a new venue, let's say, would then be barred from putting in HHR, and any charity who wants to operate or to get into the gaming activity at one of these venues would be barred from using the revenues of the HHR that are there existing. Is that correct?
That's correct. That's the current law. We currently have a limit to 14. This would expand that to possibly 18, as I understand.
Representative Ames.
Well, thank you for raising the question, Representative Ulrich. And I think we're straying a little bit from this public hearing on the amendment. This is the discussion we need to have amongst ourselves. But I do want to say that nothing's permanent in this legislative world we operate in. And some of us on this committee are on the Gaming Commission, which has as its charge this very subject of competition and location of charities that can do HHR. And we're going to be addressing that. I welcome this amendment because it doesn't open the door to the world. It allows time for the commission to think about this issue and maybe come down exactly where this amendment brings us to, but maybe it comes down at a different place. I doubt that it will come down with a wide open door to anybody, but it may propose limits, and then it's up to the legislature to adopt that. In the meantime, this new limitation will be in place if it's adopted by us and by the legislature until the legislature decides to change that. That's the way I understand it.
I totally agree with you, Representative. I shouldn't have used the word permanent. Obviously, we know that one legislature can't bind another, and you folks may decide next year or the year after to make some modification after the commission does its work.
Thank you. Thank you, Representative Ames. I think that was a helpful comment. Any other questions? Do you have one?
I have one for Representative Doucette, who should have
Okay.
been testifying, I think.
Okay, we're all, thank you.
Thank you.
Did somebody have a question? Okay.
I do have a question after Mr. Newman
Okay.
steps away from the table.
Thank you, Mr. Newman. Representative Doucette, I think we'll bring you up to the podium up here for a question.
Thank you.
No worries.
I don't have the other one, but on 2358H, and I think it's been there before, but on the new paragraph on line 26, which apparently rephrases the language that the Lottery Commission was using to not permit a license granted to be transferred or sold. Does that help in any way with with the chicanery that's been going on for the last 6, 8 months, 12 months, whatever?
I thank you and appreciate the question, Representative. I'm not sure if lottery is prepared to, and I don't know whether attorney,
What does the change in the language do then?
Yes, Representative Ames.
This is not a change in the language, it's a move of the language to a different place.
Oh, okay. Thank you.
Thank you. Any other questions for Representative Doucette? Yes.
I'm not sure technically if it's for Representative Doucette or just in general. I want to clarify that there is nothing in any of our licensing language that requires New Hampshire owners, potential owners, to be given favor over out-of-state or out-of-country owners. Is that correct?
Representative Doucette.
I believe you're correct in that, and also, and thank you for the question. And I believe that may be something that the commission can take up. And yeah, I don't think it negates any citizen from applying for a business in New
Right, but
Hampshire.
it does not give them favor over, say, someone from California or.
That's not written in the statute that I'm aware of.
Thank
no.
you.
Thank you. Representative Fellows.
I actually have a question for the Lottery Commission.
Okay. Is lottery here?
Values search.
Okay. Turn your mic.
Valerie King, New Hampshire Lottery, and I just want to add that Charlie and John are on their way. They had a different time on the calendar. So if it's something I can't answer, they'll be here shortly.
Miss Valerie, your last name again?
King, K-I-N-G.
Representative Fellows.
Yes, I just wanted a little brief description of the states of the steps in the application process. You know, do they fill out a paper and send it in, and or do they have to go, you know, get approved for this in step number 1, and then step number 2 is looking at something else related to the license?
And we're talking about HHR specifically, right? Yeah. So the first thing they would need to have is their Games of Chance game operator license and a facility. And at the same time, they'd also complete an application for a historic horse racing. What we do is we do have to determine suitability first. That's something that we do the legwork, and then we send it to the AG's office for their review and approval. If they're found suitable, then the next step we would do is we have to go visit the game room itself and make sure it's ready for operations. We check that the machines are set up, that the cage operations are ready, and that they're ready to go. We don't issue the license until we feel confident they are ready to go live.
Follow up? Or are you all set?
So do you know where the 4 that or so that are in this middle ground, they've applied? Do you know where they are in the process? Or have they all gone to the AG's office, or?
I'm not sure exactly how much I can disclose, but I can tell you that we have applications at this point. They haven't processed past applications.
Follow up?
So are they complete applications? Did they submit to you an application that had all of the information that was required to process their application?
It varies. Some yes, some no.
Representative Almy.
Mr. Chairman, I believe that we can't ask her to divulge information she is not allowed to divulge by the lottery rules. So we'll have to wait for, on the head of the lottery commission.
Representative Schamberg.
Thank you, Mr. Chairman, and Representative Almey's brought up a good point. If the investigation, I'm sorry, I should look at you. If the investigation of the applicant has been completed, Mr. McIntyre, the director, when I asked him who they were, he said it was confidential. If it's been completed, is it still confidential?
That's probably an answer that John or Charlie can give you because they're attorneys.
Well, all right. Well, maybe.
We consider them, it's, far as I understand, we consider them to be confidential until the license is issued.
Well, this is, if the director will be here while we're still in the hearing, that I would like to have the rest of my question for him to be addressed at that time.
Well, what we can do, we'll be having a exec session on this.
Well,
We can
Well,
ask that question.
Maybe I should just give what I'm looking for, and then you can relay it, and then the information can come back to us. When Mr. McIntyre had said it was confidential, the governing statute is RSA 287-D, games of chance. And in particular, in the above statute, 287D5, it deals with the application process, and 287D8 deals with specific related to the game operator license, which is the master license. That a gaming operator must have it, which you've, I think, expressed, before they get a historic racing license. And this was referenced, I think, by Representative Doucette. Okay. Oh, well. Shall I wait for Mr. McIntyre to maybe take this question?
I think that would make sense. And Ms. King, if you can fill out a pink card. When you got a chance, you can fill out a pink card. And all right. Yes. Director McIntyre, thank you for coming.
Good morning,
And,
Mr. Chair, members of the committee. Charlie McIntyre, New Hampshire Lottery Director. My apologies. I thought this was at 10:30, not 9:30, so I miscalendared it. So may I call?
We
upon?
do have a question for you from Representative Schamberg.
Okay.
Thank you, Mr. Chairman. Thank you, Mr.
Good
McIntyre.
morning.
You had mentioned in our last meeting that the names on the list were confidential.
Yes.
And I've done a little bit of research since then. Is their names are still confidential because they're still being investigated in the application process? Or is that process over right now so that we can get the list of names before maybe we vote on this?
So the reason the names are confidential is because there's a suitability review during the application process. We review the individuals in question and decide whether they're suitable or not, so that if they're determined unsuitable, that would be confidential, as you can imagine. Those reviews haven't, I don't believe, have finished yet. Yeah. And moreover, the list actually is, I was informed that it's actually now 5 locations, not 4.
Well, follow up, Mr. Chairman.
Follow up?
Well, the reason I bring this up is that the word confidential only appears 3 times in the entire 287-D, which referred to the confidentiality of results of the investigation of applicants and the results from criminal check.
Yes.
Am I right in
Yes.
that
but-
interpretation?
Sure. Just
Okay. The first time in the instance of the word is prefaced, notwithstanding RSA 91A, which implies that everything else is subject to 91A. In the Ways and Means testimony that you gave, you told me you could not release the names because state law prohibits you from doing so.
yeah.
And I'm having a hard time just figuring this out. So I guess
Certainly,
When are these names ever going to be released?
when they are approved for a license. Because here's the difficulty, Representative, if I could sort of phrase the question or phrase the answer in a different way. If I tell you the names of the individuals that applied and then they're not licensed, the confidentiality of that suitability is no longer valid because in essence, you know that they weren't suitable for some reason. You can sort of think nefarious thoughts about it. So that's the difficulty in telling you who's applied, because if they then are not licensed, they were then found unsuitable, which would be, in theory, a confidential fact. More than theory, in fact.
Follow up? So, Mr. McIntyre, then the only people we're ever going to know who has applied are those that are suitable, and the rest we never know who has
Correct.
applied at the end of this process?
Correct. Would be, that's not as dissimilar from other licenses across the state, I don't think.
Representative Fellows.
Yes, so my questions are kind of related to this application process. In what we're looking at for an amendment, it says that there's an exclusion for applicants, entities that applied for a license. So my question is, I don't know how extensive the application is, but I'm wondering if somebody could have just kind of like put in their name as a placeholder as opposed to filling out the complete application. And if it's an extensive application, then there could be a distinction between those two.
Good morning. John Conforti, Chief Compliance Officer for the New Hampshire Lottery. The application itself is not extensive. However, there are several requirements, operational requirements, those types of documents, such as internal control, surveillance plans, game rules, those types of things that need to be completed in association with the application. So as you know, we just walked in here. I think if you can have submitted an application, and it would not be complete until all of those subsequent documents would be both submitted and then reviewed. And that typically happens closer to the time of operation. I don't know if that answered your question.
Representative Almy.
Thank you.
I didn't catch your name, sir.
I'm sorry, it's John Conforti.
Got
It's Conforti, and the Chief Compliance Officer for the New Hampshire Lottery.
Thank you.
Representative Almy.
Yes, when they're ready. I would like to ask, in the document that we are looking at and the next one that's coming up, it says applied for a game operator employer license between January 1, 23 and October 18, 23. That's 3 weeks ago. We're only now learning that there's a fifth one. Did they apply before the 18th?
So Representative Almy, I was informed by staff this week that there had been an application that had been submitted in July that neither Director McIntyre or I were aware of because it had not progressed very far beyond the application stage. But we just learned about that literally this week.
Could there be more?
Follow up.
Well, given that we were made aware of that this week, I did inquire of our staff as to whether there were any other pending applications or things that could be pending, and that was the only one that I was made aware of.
Thank you.
Anything else? Yes, Representative Elberger.
Thank you, Mr. Chairman. I just want to clarify that there is no opportunity. Thank you. There's no opportunity for any kind of public input on any of these applications.
Yeah, that is correct. There's a excuse me. Sorry, I didn't see where the question came from. There is a review process that involves the Lottery Commission and the Attorney General's office, but there is not a public input component with respect to the gaming license. There may be with respect to any of the local approvals that they may need to open an establishment. But as far as our licensing process, there isn't a public input component of that.
Follow up.
Follow up?
Thank you. So, being a suspicious type, if there is somebody who may have had experience that's not public or publicly known with a license, someone who is a license applicant, and that information might be germane to the decision as to whether to support the license application or not, there's no way for that person who might know something that would be useful to get that information to you.
They would not necessarily be aware that there would be an application pending. We do try to, on our own initiative, do as much investigation, and obviously the Department of Justice does as well, to obtain as much information as we possibly can on a prospective applicant. But you're correct that somebody would not necessarily know to come to us based on public information.
Thank you.
And I would think that that would be a potential issue for all sorts of avenues where we depend on agencies to do the investigation. Representative Platt.
Just point out to me the obvious. If there were a public input process, would that not negate confidentiality?
Well, yes. Certainly the process has to go before the town before they finalize their license with us. They have to get approvals because we have to know what it looks like, what the build out is, the surveillance cameras, as compliance officer suggested. So,
Any other questions, comments?
I do.
Yes, Representative Southworth.
Thank you for taking my question. I just wanted to double check. There's no problem with eliminating the annual financial statement. It's redundant, or there's some reason you don't need it anymore.
We looked at that, and based on other requirements that we have in the rules, and both on the historic horse racing side and the auditing rules that we have currently, that was really redundant information at this point.
Great, thank you.
Yes, Representative Notter.
Thank you, Mr. Chairman. Are we allowed to know the locations of the establishments?
we haven't sort of notified folks' locations, so we've maintained that as confidential.
Thank you. Yes, Representative Leapley.
Thank you. It seems that the fundamental question is, what is confidential? It seems like this, I'm not an attorney. I'm an average person representing average people, and an average person reading this law, it sounds like the protected information is the outcomes of the criminal check and the background check. I don't understand that an applicant would have a right to apply in secrecy, and I'm not sure why they wouldn't want people to know that they're applying. So it sounds a little bit like there's been some creep in the interpretation of the law. I'm not sure why applicants deserve secrecy in this. It seems like we're talking about something it doesn't seem like you would need to maintain your fact that you're applying as confidential, or the fact where this might take place as confidential. So I guess my question is, how did you arrive at that interpretation of the state law? Was that your own? Was that the AG's interpretation? Thank you.
Well, one of the difficulties in maintaining confidential information is that once you've released it, you no longer get to bring it back. You understand my point is, if I release the list and then I was found to be in violation of that, I violated the law but we haven't sought opinion of the Attorney General in this regard specifically, no. Only because it's come up only in this context. it really, so for years, nobody's ever asked what the list looked like and who was applied. The only reason is in this context of the moratorium and these dates in question.
But so let me
Follow-up.
may I restate my question? So my question is, what do you understand to be confidential? It sounds to me like the state law is protecting information. The information that's protected is the results of the background check and results of a criminal check. It doesn't sound like the list itself or the identity of an applicant itself is protected. Is that your interpretation of the law? And how did you arrive at your interpretation of the law? Was it your own?
The answer is yes, it's our interpretation of the law. I'm happy to review this with the Attorney General's office subsequent to this. But
And-
certainly our interpretation only because the state usually balances the protection of confidential information more than it does the release of it. But that's just our understanding. We're happy to review this with the AG.
But my question's not about releasing or not releasing, just to be clear. My question is, what information is protected?
Yes. Representative Ullery.
And this is addressed to Representative Leapley. Having formerly held a private investigator's license from the state, you can't find out who is or is not a licensed private investigator unless it directly involves you. That's a privacy restriction on that particular license. Remember, a license is a grant to do something that is otherwise illegal. There are several other licenses that are granted by the state that are confidential in order to protect both the licensee, particularly in my case, from malicious activity, and to protect the public in general so that they don't have a large number of, oh, you do this, you do that. Granted, most private investigators want to advertise, but they'll advertise a business address rather than a personal address. And on a private investigator's license, they need to give the personal address. Just that type of activity. So I understand where they're coming from in the lottery, and I'm hoping that you can see how you can translate that over to the lottery activity. There is a question, and regarding whether or not the public should have input as to the licensee's suitability for the project, and I'm glad that we're going to check that out with the Attorney General. And follow up, Mr. Chair?
Follow up.
And Mr. McIntyre, if somebody wants to put in a facility, they still have to go to a public hearing in the town in which the facility wishes to behave, and there's ample time at that point for the public in general to make a protestation of one type or another. Is that correct?
Actually, to follow up on that, thank you for the question, Representative. There's even more input than that. Each city or town is certainly free to zone as it sees fit to where the activity would best be suited for the town. A number of jurisdictions have zoned in this activity to certain areas within the town. So not only do they have their rights during the hearing process for permitting and zoning, the town itself has a right to vote saying it belongs in industry A or business, whatever. A number of towns have done that. So there's more than that type of input.
Thank you, Mr. Chair.
Thank you. Representative Almy.
Thank you. Isn't it true that the town has almost no rights of control over that casino, and that on the zoning has to be done before the idea that a casino might be interested in your town shows up, because at that point they have a right to come in?
I would say yes, Representative Almy. They have, obviously, anyone who applies for a building permit or other permit or application through the town has the same rights that any other business would have. I think to Director McIntyre's point that the town or city where this would be going in would have oversight over the casino only to the extent that they would have oversight over any other business that's applying for a similar license. So with respect to the gaming portion of it, they would only have that sort of right to restrict through zoning, which many have done and are continuing to do as gaming is now expanded and the potential for a gaming establishment to come into a municipality is growing. So a number of the municipalities are addressing that before an application comes forward.
Okay, Representative Elberger.
Thank you, Mr. Chairman. Can a community simply say we're not going to allow gaming here
No.
if you've approved a license?
Sort of prior to operation, we would seek the town's approval. The operator itself would seek the town's approval to begin operation. I don't want to get too into this because there are certain communities that are opposing facilities currently. And I don't want to speak to it because there may be litigation. But certainly the town has its rights regarding zoning and permitting to approve the activity or not as it relates to zoning and permitting. If they're silent on the issue of gaming, it's a difficult question.
Just follow up.
Follow up?
It's not a question, but it's more of a statement. So a community doesn't have the ability to say no, and before the process has gotten very far down the road, nobody knows who's applying for a license or where.
Well, with respect to the town or city, the process is the same as it would be for a restaurant or a bar. So they would have to initiate those processes, and Director McIntyre is a lot smarter than I am. I am not an expert on local zoning laws. I'm barely, conversant on the things I'm supposed to be conversant on. So I can't tell you what that process looks like for a town or city. But certainly they would have the same insight into that business activity that they would with respect to every other business activity. But with respect to our licensing, you are correct. They would not have insight into that.
Okay. Seeing no more questions, we'll thank you very much. Is there anyone else who hasn't testified who would like to testify? Okay, seeing none, we'll end this public hearing. All right, the time being 10:28. We will start the work session on HB 121 relative to worldwide combined reporting for unitary businesses under the business profits tax. Does anyone have any comments? Yes, Representative Spilsbury.
Thank you, Mr. Chairman. I had the duty of chairing the Commission on Combined Worldwide Reporting that was authorized by the legislature in 2022 under HB 102. And everyone's received the report. It was an extensive report, 16-page minority report. There were 7 commissioners and 6 adopted that report. There was a qualifying statement from the association, the Society of CPAs and the DRA that they were neutral on the recommendation but endorsed the report. There's a minority report from Representative Schamberg, minutes, and a bibliography, all of which is posted on the General Court's website on a page dedicated to the Commission and accessible with links and citations and so on. So it's a lot to have read. I hope most of you have had a chance to read it. I'm not going to get into reciting the report because it's very involved, very complicated subject. And I would say if you haven't read it yet, the first 8 pages are a very neutral, measured recitation of all of the positions and opinions that the commission heard. And you can jump to the findings if you don't want to wade through that detail. The findings, analysis, and recommendation can be read in several pages. So succinctly, the commission recommends that New Hampshire does not implement combined worldwide reporting, and that it rests with the water's edge limitation currently in statute. Therefore, the commission recommends that HB 121 is not moved forward. And the commission it makes a second recommendation that there is no need for further study at this time, but there are conditions that may be worth monitoring and could change the environment in coming years, particularly if the federal government takes a different stance. So currently our law aligns with the Internal Revenue Code. Currently, the bottom line on a business's federal tax return is the point of departure for a New Hampshire return. And if HB 121 was to be adopted, it would completely delink us from the federal IRC. It would require multinational businesses to prepare an entirely different sort of tax return. And we would lose all of the benefits of piggybacking off of the federal code. We would also lose all of the positive impact of the massive audit work done by the Internal Revenue Service that the New Hampshire Department of Revenue Administration is not equipped to do. So I'll leave it there and glad to answer any questions.
Representative Platt.
Yes, Representative Spilsbury, are there any other states using worldwide reporting?
No. The answer is no. There were about, I think it was 11 states that adopted combined worldwide reporting in the late 70s and early 80s, and New Hampshire was one of those in 1981. And that regime, although on the books, was never applied to foreign-based multinationals, creating an extraordinarily discriminatory system where the U.S. multinationals were burdened in a way that the foreign multinationals were not. And as a result of that, as well as a policy review and pressure from the federal government in regards to international relations, the state of New Hampshire repealed combined worldwide reporting in 1986. And by about that time, all of the states that had enacted it also repealed it. So we've now been about 40 years nearly with no state implementing this regime.
I'll just ask, how did the vote from the commission go? What was the vote on the members?
6-1.
Question? Yes, question, Representative Ames.
I guess this is in part an observation. I believe it's true that there are several states that have an option that a corporation, a taxpayer can avail themselves of, which is to use worldwide combined reporting instead of the other system that that state defaults to. And so California, for example, I believe Massachusetts, I could be wrong on that, and a few others have that option. And in fact, many corporations, or some corporations, I don't have detail, are using it. So in response to the question about use of worldwide combined reporting, it is being used in some places.
So that's a very worthwhile clarification. Thank you for it. There is no state that mandates.
Correct.
There are a handful of states or less that allow an option. Interestingly, the state of Maine has just gone through a study and issued a report in August that specifically reviewed the proposal of going to the option, and they decided against it. And their evaluation was that there was no benefit to the state of offering the option because it has simply created a situation where a corporation would elect whichever method was more favorable to itself.
Yes, Representative Elberger.
Thank you, Mr. Chairman. I can't picture any corporation that wouldn't choose to take the option that was most financially beneficial to them. I mean, all of us would do that in our own private lives. I am concerned about the idea that in a state where we believe that people should have the ability to, should have equal options to run their lives, run their businesses, that this commission is coming out and saying that we are more than willing to allow foreign-based companies to have an advantage over our own New Hampshire-based companies. It kind of boggles the mind that we are not saying that our local companies don't have at least the same opportunities for tax advantages or disadvantages as those that are based in other countries. Thank you.
Representative Spilsbury.
Yes. So interesting observations. Representative Elberg, I think there's two different points you're making that I'd like to respond to. First, I think it is worth noting that in a state where if we were to allow the option, there are, as Representative Ames pointed out, multinationals that elect worldwide combined reporting. And that's a very interesting thing to note because it tells you that the assumption that mandating worldwide combined reporting will necessarily be beneficial to the state, i.e. will necessarily raise more taxes, is faulty. The way worldwide combined reporting works in the briefest possible way is a corporation is required to expand the tax base they report to include all foreign operations, subsidiaries of American-based multinationals, affiliates, upstream, downstream, and parent of foreign corporations. But when you've expanded the base, that doesn't mean you're going to get more in taxes. It just means that the equation where you take the portion allocable to New Hampshire over the overall activity is going to have a larger denominator and a vastly watered down numerator. So whether you're going to end up having more tax revenue is going to depend on whether that particular corporation had a higher rate of profit with their activities inside the United States or whether they had a higher rate of profit with their activities elsewhere. And there will be winners and losers. It will be completely unpredictable. A corporation that may pay more taxes this year may pay less taxes another year. So it's a clue that where an election is allowed, there are multinational corporations that elect worldwide combined reporting, and that's because it's just as likely to be a tax advantage to them and a revenue disadvantage to the state. So it's just a completely faulty premise that expanding the base will result in greater tax revenue. The second part of what you're talking about is the disadvantage. There are all kinds of tax rules that we deploy, depreciation allowances and so on, that you can qualify for if you invest, you don't qualify if you don't invest. It's not a discriminatory system that some people avail themselves of depreciation allowances and others aren't in that situation. This is very similar. It's not discriminatory. First of all, the law treats a United States-based multinational exactly the same way it treats a foreign-based multinational. So any corporation dealing in multinational activities is treated exactly alike under the law. The argument I think you may be zeroing in on is whether there's a perceived disadvantage to a purely domestic corporation. Maybe the ultimate example would be a business that only does businesses in the state of New Hampshire and doesn't even do business in another state. But that's a business that 5 years from now could grow and start doing business in other states. That's a business that could start doing business in Europe tomorrow. So businesses aren't static. Businesses choose how broadly they want to compete, and they're not static. So I think it's also a faulty premise that there is a discriminatory aspect of the law. There are different outcomes, there are differential circumstances, but the law is even-handed.
Thank you. Representative Olney.
Thank you. I have a little bit of problem with your description of what happened in the 80s, because during the COVID, worst of the COVID pandemic, we had a Zoom meeting for several hours with the proponents of worldwide combined reporting. And one of them was the successor of the man that first developed combined reporting for multi-state work. They did that in California because the film industry was making a lot of, was avoiding a lot of taxes by filming one copy of their films and sending them for $5 to another state which didn't have a tax on the film industry, and where they were multiplied and sent all over the country, tax-free. This gentleman was, I think, almost 90. He may be dead now. But he pointed out that they started doing this across, they set up this situation in California for the other states. And then they started later on to think about doing it internationally. And they did implement worldwide combined reporting internationally for at least some period. He mentioned that the greatest problem that they'd had in terms of the work for their tax agency was that they'd had to send one person to Japan to audit something. And but that in general, all of these companies overseas were used to working in English, and so they were able to do most of it by, probably in those days, airmail. So there were apparently a number of states also that were implementing this with, not as an option, but as a requirement. But it may not have gotten too far before Margaret Thatcher got Ronald Reagan to lean on all of the states that were doing it and tell them not to do it anymore.
So just to clarify the history, if I may, it's correct that when New Hampshire first instituted the BPT in 1970, we used a separate filing mechanism, just like the IRS does. And it's also true that we enacted worldwide combined reporting in 1981. It's not accurate that we ever implemented it. So and so I did indicate before there were, I believe, 11 states that also enacted it and all repealed it. None of them still has it. So I don't think it was misstated.
Representative Platt.
That's another question for Representative Spilsbury. There are certain states, you say, who will give a choice of worldwide reporting or water's edge. And as a result of that, the businesses will choose one or the other depending on what's favorable to that business. If that's true, if we were to mandate it here, it's a crapshoot whether revenues would go up or down, isn't it? Because a business could be paying more under the water's edge than they would have under worldwide reporting. Is that correct?
That is correct. It's unknowable which taxpayers would see their tax liability increase and which ones would see it decrease.
Representative Ames.
Yeah, this experience that's clearly happened in states where the election, the option is available, should be an experience that would be help all of us understand the realities of worldwide combined reporting, not mandated, but some corporations, large, small, I don't know, are choosing to put forward their calculation of their tax liability using this accounting method. And those states, the tax departments in those states have had to respond to that, either accept it or audit it or whatever. And that experience, I would think, would be very interesting, and including any information that's available about which way these corporations go and how that relates to revenue. There must be information out there that would be helpful. My question is whether this commission looked at all to those states for information on that experience.
I think that's a very constructive question. And the answer is we took cognizance of them, but we did not do research into what their experience is. And so the commission has stated nothing to that point. However, we did specifically consider the recent Maine study and the one I referred to before, which came out in August. And that is in our record and accessible through the commission's webpage and might be worth reading. So they did evaluate specifically that question.
And just, I think you said it before, but the conclusion of that was what?
So the conclusion of the state of Maine was to not adopt the option. So they continue to be a water's edge state like we are. I'm going to give you a different example. There are a number of states in the last half dozen years that have considered and declined to go forward. Indiana in 2017 issued a very extensive report in which they said that they could imagine there would be a moderate uptick in revenue in the first couple of years that would resolve towards a net zero, and that it just wasn't worth doing. There was a proposal in Minnesota this past year that was adopted passed in the Minnesota House and died in the Senate, did not get enacted. Also very interesting is that Rhode Island within the past year has concluded a study with about a 90-page report, very detailed. It's a different circumstance, but it tells us a lot. Rhode Island uses separate filing. They've never adopted combined filing either on the water's edge limit or worldwide. So they studied the question whether they should move to combined reporting, and they concluded that they wanted to stay separate reporting in line with the IRS. So I won't characterize their study, but 90 pages and a lot of detail. and they weren't even willing to go to the water's edge.
Thank you.
Weren't willing to go to water's edge?
Rhode Island decided to leave their law as it is now, which is separate filing rather than combined.
Representative Leapley.
Thank you. So I have two items. My first question is about the makeup of the commission. It seems like it was very small, and it seems like it wasn't entirely representative of people who might have an interest in this item. Can you talk a little bit about the makeup of the commission?
So the commission, of course, was dictated by HB 102, enacted in 2022, and it described 12 members. And 7 of those appointments were filled. 5 were never appointed, despite repeated requests, initially by Representative Abrami when he was first seated as chair, and then further renewed by me several times during this summer. So both of us, through the House Clerk, Paul Smith, made an effort to try and jog the other listed interests, so that, for example, the Department of Economics and Development, is that what it's called? DEA? Taylor Caswell's department had a member. He left the department, and they did not fill that vacancy. The Attorney General did not make an appointment, and there were a couple of other BIA positions, 2 of them that were never filled. But I will tell you, Representative Leapley, that we went out of our way to make sure that we heard from everybody who indicated an interest in speaking before us. We also went out of our way to structure the hearing so that the New Hampshire-based interests were up first and had an opportunity to frame the issue. And I referred to that in the commission's report as New Hampshire-centric. We wanted to put them up on the platform and let their opinion be centered first. So we certainly did try to hear, and nobody who indicated an interest in presenting to us was turned away.
I have a follow-up.
Follow-up?
Thank you. I certainly appreciate the commission's work. I certainly appreciate your work. It was very serious and I know time consuming, so thank you for that. I want to talk about framing the issue because I feel like that's really key here. We've addressed the assumption. It seems that what was framed here is the assumption that this would necessarily raise more taxes, and that assumption was found to be false. I don't think that was the central focus. I think it's an important focus of this commission, but I think an equally important focus of the commission is tax justice and fairness. And so I think it might be slightly misleading to frame this as you want to raise more taxes, this doesn't do that, and therefore we should not pass it. I think a question that's equally important is the fairness question. And we don't know doesn't equal it won't. And I feel like almost everything we do in this committee is often there's a lot that we don't know about how changing taxes will affect revenues. So I think that that's not particularly different or special in this case. There were some things that were raised that I actually read as opposite of the commission. For example, there was a lobbyist that shared the information that 14%, there was a 14% growth in international, thanks to international foreign multinationals in the state. There was a 14% increase in employment by those firms, whereas the rest of the economy only grew 7%. And therefore, this is a very important base of taxpayers that we should treat carefully. And my takeaway from that is if they're growing their employment by 14%, everybody else is growing it by 7%, I want to make extra sure that they're paying their fair share of taxes so that we can develop a workforce. If they're drawing on our workforce disproportionately, it makes sense that they pay their fair share of taxes, right? So yes, it's a benefit. It's wonderful that they're generating employment. It costs the state money to educate people. So I don't necessarily have the same takeaway on some of these issues. Another point that was made in the commission study by someone who presented was that New Hampshire, we're actually doing a great job of corporate taxation because we have the biggest percentage of our income is coming from taxing corporations. So we're doing great. So we shouldn't tax them any further. And my takeaway from that point was that, again, if this is the biggest part of our taxation, we need to be extra sure that we're taxing corporations fairly because we have a greater interest, greater than any other state, in the outcome of that taxation. So again, I don't think that that's we better take our hands off. I think we better be extra careful that we're taxing fairly. A third point is that we're talking about picking winners or losers, and we don't want to pick winners or losers. It's ironic in the deep sense of irony, because this bill was brought forward because the argument is that the state is picking winners and losers currently, and we would like to stop doing that. And I think the argument that the law is not discriminatory, that we treat all multinationals the same, is missing the point. We're not talking about multinationals not being treated equally. We're talking about people who just exist in New Hampshire, who don't exist multinationally, who are not taking advantage of these very expensive, sophisticated accounting techniques to avoid taxation. They're paying taxation on their full revenues. So I think that we should proceed carefully in deciding that we're treating all of them the same. My final point is the commission report seemed to claim that there was no proof that there is tax avoidance going on, whereas the OECD, which I think is a pretty credible international body of over 140 countries, says that there are billions and billions and billions of dollars that are not being taxed. So I think this is a real problem. It's a real problem that New Hampshire is interested in, more interested in than other states. So I don't want to be dismissive of this very difficult question. I think the commission did a great job. I think this is worthy of further consideration, and I think it is worthy of being discussed by our legislature because we have a bigger interest in this than any other state in the country. Thank you.
Thank you. I saw Representative Plett first.
Thank you. Thank you, Mr. Chair. Representative Spilsbury, you stated that you gave New Hampshire-centric businesses first opportunity bite at the apple. Did you find any support for from New Hampshire businesses for worldwide reporting?
Yes, there are definitely advocates, and we had a representative of a business association with two other people with him, and they made a passionate case in favor of worldwide combined reporting. So yes, we did hear that. But that doesn't mean that it was a fact-based case or that it was a quantifiable case. it was a theoretical case.
If, yeah, thank you, Mr. Chair. Would you not expect if New Hampshire businesses thought that worldwide reporting would raise taxes for people outside New Hampshire, that they'd be supported as a competitive advantage? Because they won't pay it, but others will?
Let me make sure I understood what you asked. You just asked if I thought more revenue could be derived from foreign multinationals, would not New Hampshire businesses be urging that we move in that direction? Is that what you asked?
There's a competitive advantage because they're screwing the other guys.
Well, perhaps. I will just say I was surprised that there wasn't more uptake and more businesses that came forward and wanted to give us some at least anecdotes. I'd like to give credit to Representative Leapley, who attended 2 of our very long sessions, including the all day of hearings. She's obviously deeply interested. So if I could take another couple of minutes just to address, distilling the various points you've made, you're concerned with fairness. And I want to be very clear. The commission did not state that there is no problem. The commission went out of its way to explicitly acknowledge that the opportunity and the potential for misusing transfer pricing techniques, allowable, justifiable techniques that may be used specifically to shift profit to a lower tax jurisdiction overseas. That opportunity, there's no question it exists. There is no question that it's used. The problem is severalfold. The problem is, number one, it's not quantifiable. And any efforts to quantify it can be very effectively rebutted. Second, it's not clear how extensive it is or whether it represents a truly material problem for the state in terms of our goal of generating revenue. Number 3, it is drastically overbroad. It basically takes a concern that certain taxpayers are using transfer pricing, let's say, to shift profits on the basis of licenses or royalties or other payments for intellectual property and intangibles. And it says, okay, so here's the solution. We're going to require you and everybody you're related to declare all of your worldwide activity and your profits in every country. I used to work for a multinational that was in 76 countries. So that corporation would have to file its activities. It's basically translate its tax returns from foreign currencies and foreign languages and foreign general accepted accounting practices. It is drastically underestimated what kind of a burden this is going to place on the taxpayers. It is drastically underestimated and not understood what kind of a challenge this would place on the DRA. So I think that if this was perceived as being the right solution to the perception that there is a fairness problem, we would create far more problems than we solve. And you've got to really ask yourself, why is it after decades and decades of controversy that the U.S. Congress has never tried to implement something like this? If the United States government doesn't think it's worth going after in this fashion, then how in the world is New Hampshire going to effectively move in that direction on its own? And what do we give up when we delink from the IRS and from the code? The contours of this proposed solution are not even slightly in alignment with the description of the problem, even if you accept the problem as genuine.
Thank you. Representative Ullery.
Thank you, Mr. Chair. Having been on the commission and attended the, at least this year's sessions of it, a couple of things came to mind. The question regarding fairness of treatment of taxation was raised repeatedly. And if I'm not mistaken, one of the comments was that the same tax code applies to every person in this state currently. There is a difference in magnitude of scale on some of the corporations, to be sure. And that's going to happen regardless of what kind of system is put in place, magnitude of scale. There was also a discussion as to whether or not that what the tax foundation rates New Hampshire, I think, is number 6. Rich states, poor states has it, New Hampshire in the top 20 for the business environments. That question was also raised as to whether or not it would have an adverse effect upon businesses, particularly large businesses in the state of New Hampshire that rely on high tech. New Hampshire has become a high tech environment. We've got some stuff in this immediate area that really causes people to take pause as to where they're going because of its proximity to Boston, because of the tax environment that exists for the corporations. So if the fairness is, are we going to trade off employing people in the state, increasing revenue from the BET, BPT, which is applied equally to every single business? I believe Mr. Keene was there and made that a comment to that effect. Then we have the question about what is it? Price transfer, which is take the technical term for moving from place to place, monies. Of course that takes place. Most businesses in New Hampshire do it all the time, large or small. And I believe the report that was created said that it does take place. But as to the degree whether or not this was hiding profits from taxation or merely taking profits from one business here and giving it to another business over there, not for the purpose of hiding profits, like a greedy, rich business would do, but to help another division of the same company be more successful, hire people, and produce a product, a good, or something, or services that people want. So that was pretty clearly stated, if I'm not mistaken, in our report. Is that correct?
Well, yes, and I think those are extremely valid points. For those who've had a chance to read the report, yes, you'll see that that's very clearly stated. So for those who haven't had a chance to read the report, I'd like to just say categorically, transfer pricing is legitimate. It's necessary. It's actually required. So the question isn't whether transfer pricing is inherently bad. The question is whether transfer pricing is used by certain people to minimize or reduce tax. I give you an analogy. If a parent owns a patent on a recipe, they're going to charge their subsidiaries for the use of the recipe, right? A parallel. Instead of thinking in terms of complicated multinational businesses, think of a franchise operation. If a franchisor has franchisees around the country and some franchisee has a dozen Subways, that franchisee under contract agrees to pay for the recipes, the brand name, the marketing program, and so on. So inherently, you're going to have subsidiaries making payments to a parent for the use of those intellectual property and other intangible assets that the parent owns. That's what transfer pricing is. It is not inherently bad.
Representative Almy.
Thank you. I'm kind of appalled, and I'm sorry I was too sick during a large part of the work that you were doing too, and then too busy to be able to show up. And there is substantial data on tax havens around the world. That is something that is not something that is just transferring profits for the purposes of the success of the business, except to reduce their taxes. There are a large number of corporations that have been shown to pay almost nothing to the maintenance of our federal government because they are using a lot of these mechanisms. And there were several studies done on before we started getting into this business that showed on quantitatively that there would be an increase in New Hampshire tax revenue if we could figure out how to do this. There are other reasons why we may need to do a bunch more work on how to get it done, but to abandon the entire principle because all of this tax evasion is going on internationally seems to me to be extremely ideological, frankly. Thank you.
Yes, Representative Spilsbury.
Yeah,
Answer.
one thing I'd like to promise all of my colleagues on the Ways and Means Committee is that the commission did not proceed in an ideological way. There was no preconceived conclusions. It was an extraordinarily comprehensive and balanced review, and you'll see that when you read the commission's report. I think most of your observations are accurate. And so in no way did the commission in its report try to pretend that this doesn't happen. But it's an international problem. It's a problem that the IRS deals with. It's a problem that Congress has considered from time to time. It's a problem that's been addressed in a host of different ways through our work with the Organization of Economic Cooperation and Development, OECD, the Pillar 1 and Pillar 2. There were major aspects of the 2017 Tax Cuts and Jobs Act that focused on this problem because it is real, right? And so the guilty, we tax guilty at 50%. We also, New Hampshire also taxes all foreign dividends when repatriated to the United States. So there are a host of different methods and ways of trying to address the problem and mitigate the problem. I don't think anybody has devised a solution. They haven't devised a solution on the international level or the national level. And I think it's a bit delusional to think we're going to suddenly do something here that's going to create a solution in New Hampshire. Without getting into the weeds, I would also just suggest to you, even if you think that worldwide combined reporting is the right thing to do, HB 121 doesn't do it. If you read HB 121, 80% is prefatory language and history, some of which is debatable. The actual active language of the bill is a list of 6 provisions that would be repealed so as to eliminate the water's edge limitation. And then there are 2 provisions in law where a sentence or a portion of a sentence is added. In our hearings and in our commission discussion, the DRA's representatives made it very clear that this bill would be inadequate to do what it even purports to do It's completely lacking in a mechanism. It's completely lacking in definitions. It gives the DRA no guidance whatsoever. In fact, if you go to page 3 of the bill, it essentially rests on a single sentence that's been added at lines 24 and 25. This provision shall authorize the application of worldwide combined reporting. That is not legislating, and that doesn't actually give the DRA anything that they can go work with. So, you know, maybe another bill in another legislature for somebody who still thinks this is the path to take, but this bill is not the path to take.
Thank you. Now, I'll recognize Representative Leapley in a second here, but let me first say that any more comments, let's try to keep them to new thoughts, because we are, the time being almost 11:20 and we have a lot of work to do. Let's try to keep it to new comments. Representative Leapley.
Thank you. So I have a couple thoughts. First of all, this being the Committee on Ways and Means, I think it is our job to be extremely curious about taxation and to learn as much as we can about who we tax in the state, how we tax in the state, how taxes are avoided by taxpayers in the state. And avoidance, just to be clear, is legal. So I'm not casting aspersions. So one, I think it's our job to ask these questions and to be curious and to try to understand these issues better. It's very hard as an everyday person to understand what is happening here. A lot of the discussion of the commission, when it got into details, would, for example, be about guilty. What is guilty? We tax guilty, and so therefore we're capturing this federal money. And an everyday person is like, "What's guilty? Oh, we're taxing it. Okay, so we're all set." So what I'm getting at here is that it's very easy for this to go into such technical language that the actual questions being asked aren't answered. Guilty is taxed at a 10% rate, between 10 and 13% in the state of New Hampshire. I think that an everyday coffee shop, maybe Revelstoke downtown, would love to pay 10%. So if we're saying something, kind of tossing it off that, oh, we tax guilty, so we're all set, like, let's acknowledge that that is not the corporate tax rate that is normally taxed. The other thing I want to bring up is, yes, the OECD is tackling this. Yes, Pillar 1 and 2 are perhaps solutions. Again, I'm just an average person, but my understanding right now is that while the U.S. Has signed on to BEPS, we are not participating in Pillar 1 and Pillar 2. And if, as a New Hampshire taxpayer, I think it's important that we have this discussion, because if our federal government is not going to sign on to Pillar 1 and 2, and we don't even understand what that means, one of the things it could mean is that the other 140 countries are starting to get their taxes back from these multinationals, right? So, big company A, France is going to get their 20%. Micronesia is going to get their 20%. But if we don't start paying attention to what is going on internationally, we're not going to get our share. So I think it is in the interest of New Hampshire to talk about these very complicated, unsexy issues, maybe even talk about them on the floor of the legislature so that they can be more widely understood, and so that we send a message to the federal government that the choices that they make affect New Hampshire, because as it stands now, we are dependent on what is happening at the federal level. So if they're not opting in to international tax treaties that capture the real revenues made. And just to be clear, when we're talking about, this being very difficult for companies to file taxes that show the actual revenues made, on the international level, we're talking about companies that have revenues higher than $750 million a year. So if we're going to talk about, taxes are really complicated and hard, these tax avoidance procedures are really complicated and hard. And that's why our local New Hampshire businesses, while you're right, technically, legally, can use these same tax avoidance structures, they're really expensive. And if you make $1 billion a year, it might be interesting to you to execute that. But if you're just a mom and pop, it's not. And I'm thinking about my own kids. They would like to grow up and build their own businesses, right? So they might want to have a Revelstoke more than they want to go work for $17 an hour at Starbucks. So when we're talking about these issues, we're talking about the future of our kids, and their ability to compete as business owners really matters. So I hope that the curiosity that this bill and that this commission has raised won't end with this commission or today's discussion, but will increase, because this is really impacting us in New Hampshire and our kids in New Hampshire. I know it seems very far away and very international and very high level, but this kind of stuff is impacting our retailers' ability to stay in business every day. So I hope that it will stay in our consciousness. Thank you.
Thank you. Anybody else? Okay. I'm going to close the work session on HB 121. And we'll now open the work session on HB 192. Representative Almeid, you might have a point to make.
Yeah, this one is easy, I think. This bill was written with the assumption that the I&D tax exists. The I&D tax will cease to exist on the 31st of December of this year. This bill would come to the 1/1/24. No, it is repealed as of the end of this year.
I believe HB 2 has it repealed by the end of next year. By the end of 24.
Yeah, 2%.
There was a
next year.
difference between the bill. So the bill that I sponsored had it ending at the end of this year, but when it got into HB 2, it actually ends at the end of 24.
Could we ask Mr. Wong to? Because
Well, does that distinction affect your comment, your point? Well, Mr. Wong is at the podium, so we'll, please introduce yourself and,
Good morning, Tim Ming Wong from the Department of Revenue. I believe, if memory serves me, that the repeal is effective for taxable periods beginning after December 31, 25.
yeah, for tax periods ending.
Beginning
But-
yeah.
But when I tried to reference in a new bill to reference RSA 77, I was told that that will no longer exist. 1/1/24.
well, I don't know. That was the bill as introduced, but in HB 2, it ends 12/31, tax periods ending 12/31/24.
Yeah. So
But that doesn't affect your point, does it?
It doesn't affect my point in the sense that having been told that I could not act on a law which is repealed, on that I decided to get more ambitious about this, and I have written, with help from DRA, I have written a total rewrite of the century-old law and set it up in a new chapter that will be heard in January, which does do the same things of increasing the exemptions, tripling the exemptions, because they haven't been changed since before my time here, which more than 30 years. I'm not sure how far back it goes. And that bill will be coming forward. And this bill, as I was told, could not happen because it is based on something that is being repealed. So that is already repealed for a future date. And you're making it a lot more complicated than I thought it was. But so I would be willing, when we get to the voting session, to move ITL on this one, partly also because the existing law, which dies either the end of this year or the end of next year, was written in the beginning of the 20th century and has been accreted onto in ways that make it very, very difficult for anybody who's not a tax expert at IND law to know what they're doing. So, so that is what I'm planning on doing.
Thank you. Any other comments? Seeing none, I will end the work session on HB 192. We'll now open the work session on HB 569. And Representative Ames may have something to say.
Thank you. This bill, as I think you all know, relates to the statewide education property tax and seeks to amend the provisions that govern the way in which the revenues that are raised by the tax flow through government channels back to and then are applied. The current law has the collection of the revenues by the localities, the towns and municipalities throughout the state, unincorporated townships, and then that money is kept retained locally and distributed to school districts that serve the respective towns and municipalities, in the first instance to cover costs that are part of the adequacy costing formula, and then if there's additional money that is left over after that allocation for adequacy costs, that too is retained locally. And if there are additional education costs that locality is responsible for in its relationship to school districts, it will be applied to those school costs. If, as is the case in some instances, there are no other school costs. We've got some townships that collect the money but have no school children. Then the money will be applied through bookkeeping arrangements in effect, to offset other costs in other accounts, so that those places show a negative school tax rate to make it all come out right. So this Bill 569 would change the distribution of the revenues after they're collected, and would send all the revenues back to the Department of Revenue Administration and thence into the Treasury after first a deduction at the local level for the collection costs that would be allowed. It's not allowed right now. And then at the state level, it would flow into the education fund, trust fund. In addition, the bill provides for a more extensive, more generous rebate system for taxpayers that would significantly increase the amount of relief available to low-income homeowners who are taxpayers. So that's roughly the bill. The context for this bill has been all along litigation challenging the retention of excess revenues at the local level, and seeking to persuade the courts that this is unconstitutional and must end. And a case to that effect is pending, as we said, as we all know. I've spoken about this before. It's under advisement before Judge Ruoff, and all arguments have been made, all briefs have been submitted, and he will release a decision at some point. We'd all hoped, I think, that it would come out earlier than this, and it's critical context for decision-making related to this bill. Because it's not out, and we don't know which way it will go, and we may need to respond to the new reality that decision creates for us, always mindful of the fact that appeals can follow to the state Supreme Court, so it may not be fully resolved. And also mindful of the fact that there's another lawsuit that also in the hands of Judge Ruoff that challenges the entire adequacy formula and seeks to raise significantly the state's obligations. All of that context is to be developed, and it's going to change probably. Well, my recommendation at this stage in the game, reluctantly, is to ask that we support interim study as a way of enabling us to keep our eye on this ball and to at least have discussions as new information comes out that may in the end have to take the form of a recommendation for legislation for legislation in 2025, which isn't a bad idea because that's a budget year and it's a good time to adjust things like this. And having this as a way to touch down and think about the issue is, I think, a good idea. So I hope that we can go to interim study on this bill for all the reasons that I just stated.
Thank you. Any other comments? Okay, seeing none, we'll close the work session on HB 569. At this time, I think we can take a 5-minute break, but I want to stick to the 5 minutes. Let's get back here as quickly as possible. Thank you.
Close friends.
started here?
Where should I take it to?
Yeah, it's there. Okay. All right. Is everyone back? Or, all right. So it looks like everyone is back. And I will open the exec session on SB 112. And I will recognize Representative Doucette.
Thank you, Mr. Chair. I would move SB 112 FN with, as it stands right now, with amendment number 2023-2358H.
Okay. I think we have to first just introduce the bill.
I move
So-
the bill.
Move the bill. Do I have a second? Second from Representative Almy.
And I offer the amendment.
And then
2358H.
Can't we just
Okay.
move
Yeah,
to
I was about to do that.
Okay. Do I have a second? I'm just going to second the amendment.
58?
Yes, 2358.
Because we
Second with a further motion.
Okay, Representative. Straight to what other one?
What am I missing here, guys?
We didn't, no, I can't because we can't go directly to, what is it, 2344?
2444.
2444 because we had the public hearing on 2358. We need to first introduce that. No? Let me get some clarification.
Mr. Chair,
Yes.
I move to substitute amendment number
wait.
2444H.
No, wait a minute, wait. So I've been told that if everything in 2358 is in 2444, except for the fix, a minor change, then we can introduce that. So
Okay,
Representative Doucette,
Withdraw the motion on 2358.
okay, and now,
Withdraw the second.
no, I don't think we need a second for that, but now you can introduce 2444.
Thank you, Mr. Chair. I move amendment 2023-2444H.
Do I have a second? Representative Almy seconds it.
Without knowing yet what's.
Okay, well, we will, then I'll recognize Representative Doucette to tell us what's in it.
Okay, as we discussed, it addresses most specifically the rent, the difference between the previous amendment that I offered up and this cleaned up version was I had inadvertently missed a couple areas in the statute where it spoke of the charities paying rent. And again, it addresses the moratorium on historic horse racing. But most specifically, there were three paragraphs, I believe, Representative, that I missed where it referenced rent in 287. It was brought to my attention.
Representative Almy. 5 what? Turn on your microphone.
Sorry, there seem to be 5 paragraphs. On first, on line 11, on something that was talking about charging rent is totally deleted from the law. And then in 15, any agreement entered into by the charitable organization deletes any service or rental agreement. In 18, they delete out of the circumstances of a loss from games of chance on the part and any rent paid or due is deleted. And in 21, there is a totally new paragraph. All contracts between a game operator, employer, and a charitable organization to conduct games of chance under this chapter shall contain the following language. This agreement represents the entire agreement between the parties. No charge or fee of any kind that is not contained in this agreement shall be paid by the charity.
Well,
And then finally, in 25, no, in 25, I guess that's just the same thing it was before.
It's, yeah, that's renumbered because B is
Yeah.
taken out, so they're all
Right.
renumbered.
Right.
Any other comments? Questions? Okay. Seeing none, the clerk will take the roll on Amendment 2023-2444.
Thank you, Mr. Chair. It's SB 112F and ought to pass with this amendment, so it's the amendment that we're voting on. That's correct. Chairman Janigian,
Yes.
Representative Ullery,
Yes.
Representative Doucette,
Yes.
Representative Spilsbury.
Yes.
The clerk votes yes. Representative Nodder,
No.
Representative Sodi,
Yes.
Representative Ors,
Yes.
Representative Rochefort,
Yes.
Representative Almy,
Yes.
Representative Ames,
Yes.
Representative Southworth,
Yes.
Representative Malloy,
Yes.
Representative Schomburg,
Yes.
Representative Fellows,
Yes.
Representative Bolton,
Yes.
Representative Elberger,
Yes.
Representative Leapley. Yes. And Representative Pratt.
Yes.
It's, okay, the vote is 18, 1, and 1 not voting. To, the amendment.
Okay, that's the amendment. Now we'll vote on the bill.
The vote then is ought to pass as amended for SB 112FN. Representative Janigian,
Yes.
Representative Ullery,
Yes.
Representative Doucette,
Yes.
Representative Spilsbury,
Yes.
Representative Platt votes yes. Representative Nodder,
No.
Representative Sodi,
Yes.
Representative Ors,
Yes.
Representative Rochefort,
Yes.
Representative Almy,
Yes.
Representative Ames,
Yes.
Representative Southworth,
Yes.
Representative Malloy,
Yes.
Representative Schomburg,
Yes.
Representative Fellows,
Yes.
Representative Bolton,
Yes.
Representative Elberger,
Yes.
Representative Leapley,
Yes.
and Representative Pratt.
Yes.
Oh, 13, 14, 15, 16, 17, 18. Yeah, the vote is 18, 1, and 1 not voting. Should this go on consent?
We have one member saying no. So it will not go on consent.
Mr. Chair,
Yes.
I don't think it makes any difference, because it's gonna be taken off consent agenda.
Fair enough.
Well, if
Okay.
one person
All right.
says no,
So it will
we
not,
have
it
to
will,
not do it.
it'll not go on consent. Okay, I'll close the exec session on SB 112. We'll now open the exec session on HB 121.
Hold on.
FN.
This piece of paperwork.
Um, Representative Schomburg, did you
Who moved and seconded?
I think,
On the last bill.
Representative Spilsbury.
Thank you, Mr. Chairman. I'd like to make a motion of inexpedient to legislate on HB 121.
Do I have
The last bill first. Who moved and seconded, it was-
Doucette and Almy.
okay, thank you for the indulgence.
All right, so Representative Spilsbury has made a motion of ITL on HB 121. Do I have a second? Second by
Second, who?
Representative Sodi. Would you like to speak to your
Mr.
motion?
Chairman, does he speak
Yeah.
to his motion before the amendment? He does speak.
He has
to-
to speak to his motion. Yeah.
What, my question is,
I'm perfectly happy to hold back further discussion until the amendment's been made.
Excuse me, but the.
Just
the
microphone,
bill-
microphone.
There's been a motion made and it is ITL. Unless a motion is made instead that is ought to pass, there cannot be the amendment.
well, the amendment has the application date and the issue date, the effective dates.
But it is related to an ought to pass motion.
Okay. Thank you, madam.
Sorry.
So Representative Spilsbury, do you want to, we don't, we got a second, yes. Did you want to speak to your motion?
I think we've had extensive discussion during the work session, so I'll hold back in the event there's anything I need to rebut. I reserve that time, please.
Thank you. Would anyone like to speak further on the ITL motion? Representative Schamberg.
Mr. Chairman, I contest the ITL motion, the approach. I'd like to express some bullet points and then go from there. I believe that we all can agree that taxes are our only sustainable source of revenue for independent states like New Hampshire and the other 49 states, and that our tax policies are to have a fair and level playing field for all who pay taxes, and pro-business attitudes are okay if it benefits all businesses. So why do I contest this ITL? The present Water's Edge has a blind spot about corporate tax avoidance techniques that makes the tax paying field for domestic businesses of New Hampshire unlevel and at a competitive disadvantage due to their relative tax burden. Let's go through a few bullet points. New Hampshire adopted worldwide combined reporting in 1981 and utilized it because it showed increased transparency and it was more equitable. The DRA policy of the 1983 through 1986 was driven by political pressures not to enforce on foreign enterprises. The Majority Commission report concludes that the 1981 through 1986 worldwide combined reporting was discriminatory, and it was basically based on the political commentary of the time by the governor that was in the office. And then the Ways and Means Commission then and the legislature adopted Water's Edge only to codify a real discrimination. New Hampshire Supreme Court acknowledged this discrimination in the 1999 Caterpillar decision. We point out that Water's Edge method was adopted for the benefit of foreign businesses. And how do I arrive at this? Because we have a legal opinion by the highest court here in the state. Prior to 1986, New Hampshire utilized worldwide, Supreme Court says, prior to 1986, New Hampshire utilized worldwide combined reporting, in which the net income of all members of the unitary group, domestic and foreign, was included in the tax base. In 1986, the legislature, the Supreme Court says, adopted the Water's Edge method, eliminating overseas business organizations from subjection to the business profits tax. And the New Hampshire Supreme Court said, the nature of the Water's Edge formula requires that foreign subsidiaries be treated differently from domestic subsidiaries. Most significantly, the latter's income is subject to taxation, that means the domestics, while the former, which is the foreign income, is not. And the final statement by the New Hampshire Supreme Court of 1999 in the Caterpillar case, accordingly, while the foreign members' apportionment factors are excluded from calculation of taxable profits, their income is exempt from the state business profits tax. Almost 9 out of 10 jobs in New Hampshire are provided by domestic businesses, and more than half are small businesses who pay their full tax liability, while foreign businesses can avoid tax liability on their New Hampshire profits through clever, while legal, accounting procedures. Majority concedes in their report that transfer pricing, what some might call profit shifting, exists and probably has an impact on New Hampshire-based businesses. Water's Edge violates the New Hampshire Constitution because it puts New Hampshire businesses at a competitive disadvantage and is anti-democratic, which is what the New Hampshire Supreme Court has said in their words of, it was created for the benefit and it eliminates overseas businesses from subjection to business profits tax. Little impact on foreign companies as they, going back a moment, the DRA had spoken and had the CPA organization has spoken about the effect of translations, money issues, and there is little impact on foreign companies now, as they must already prepare all the information required in the worldwide combined reporting for the federal government and the SEC. The DRA, there's little impact on the DRA as New Hampshire law already requires companies to translate into English and convert to US dollars. Water's Edge gives foreign companies an advantage, making New Hampshire businesses pay more or denying the state of revenue or both. Our domestic companies pay 100% of their total tax liability versus the reported tax liability from the foreign multinationals. While majority and the DRA say they can't measure revenue impact, it's simple common sense that broadening tax base will result in more revenue. And it is time to level the playing field. We have 2 tiers of taxation in the paying of BPT, one for domestic and one for foreign multinationals, as pointed out by the New Hampshire Supreme Court. And I'd like to do a little analogy here. Should Canadians or British or any foreign visitors to New Hampshire be exempt from the state's meals and rooms tax or the car rental tax? How about the state's tobacco tax? Should foreigners be exempt? What about New Hampshire property taxes? Should New Hampshire property owners from France or Bermuda or any other country be exempt from paying New Hampshire property taxes? Would you be willing to pay more in those New Hampshire taxes to make up the shortfall, the taxes that foreigners can legally avoid if the laws allowed it. And in today's tax notes, 360, they presented ConocoPhillips owes $390 million in transfer pricing row in Louisiana. That ConocoPhillips engaged in a series of transactions with affiliated parties that were not made at fair market value, leading the company to underreport Louisiana corporate net income and failed to pay hundreds of millions of dollars in state taxes, the Louisiana Department of Revenue told a state court. I find, as I conclude here, that we presently have two tiers of taxation in the paying of BPT, one for domestic, one for foreign multinational companies, pointed out by the New Hampshire Supreme Court. Democracy is opposed to this. There is no privileged class in the United States or New Hampshire, whether it be for people or for business arrangements. Thank you, Mr. Chairman.
Thank you. Any other comments, questions? Representative Spilsbury.
I think Representative Ullery had his hand up first.
Yeah,
Yes.
just briefly. I thank Representative Schaumburg for his advocacy. However, I think a couple of factual mistakes were made based upon information that was given during the commission report. All businesses, regardless of their status, are treated the same way under our BPT BET, according to DRA testimony. In addition, one can agree that the Caterpillar decision does say that the tax code changing to water's edge gives benefit to large multinationals. That's a function of scale. That's nothing more than that. And we do have cutouts and divisions and subdivisions of subdivisions of our tax code, which have existed for a long time. Indeed, Professor Hearn, that Representative Almy brought several years ago to this committee to talk, said that such activity was perfectly legal so long as it was perfectly legal rather, so long as it stayed within the same class of taxpayer, so that you can have a different tax rate for this person or this group of people as to this group of people who, although they may be similar, are different by definition. So I think some of the arguments that were made were passionate, however, don't really apply to what worldwide reporting will do, in my opinion. Thank you, Mr. Chair.
Representative Spilsbury.
Thank you, Mr. Chairman. Again, I don't want to repeat the many things that were said earlier in the work session, but there are several assertions that have been made that I do need to rebut. I would encourage everybody to read the commission report in full, even if you haven't had a chance to do it yet. Certainly you'll want to do it by the time this bill comes to the floor in January. You'll find that everything that's been discussed was in fact considered and addressed. You'll find that it's been addressed in a very balanced way. And I would just say, as an aside, that I've received several compliments for the quality of the commission's report in the last week. So I stand by the report. The report clarifies this murky situation from 1981 to 86. And if you look at the legislative history in which then Governor John Sununu testified personally in front of the Ways and Means Committee on 2 occasions, that's how strongly he felt about the bill. The DRA's explicit policy to not solicit or accept a unitary worldwide filing from any foreign multinational did, in fact, it created a de facto discriminatory situation. And when you read the legislative history, that was central to why it was repealed. Second, when it's asserted that Water's Edge codifies a real discrimination, and we refer to the 1999 Caterpillar case, I'd like to just read a passage from the Commission's report that includes a quotation from that case. So, the New Hampshire Supreme Court's decision in the 1999 Caterpillar case found that the New Hampshire DRA's differential treatment of foreign affiliates from U.S. taxable entities under the Water's Edge method was not unconstitutional discrimination under the Federal Commerce Clause, stating, quote, "In sum, we reject the plaintiff's argument that New Hampshire's apportionment formula unconstitutionally discriminates between foreign and domestic subsidiaries in a unitary business. The nature of the Water's Edge formula requires that foreign subsidiaries be treated differently from domestic subsidiaries, but most significantly, the latter's income is subject to taxation, while the former's is not." So it goes on to say the plaintiffs fail, however, to meet their burden in proving discrimination. Although New Hampshire's unitary apportionment formula may not apportion income perfectly, the federal Constitution does not require mathematical exactitude, only a rough approximation. And the Caterpillar Court, the New Hampshire Supreme Court, then quotes the United States Supreme Court's decision in Container Corporation of America and in Barclays Bank and others. So differential treatment is inherent in taxation. Some taxpayers are personal individuals, some are C Corps, some are sub S's, some are LLCs. Some invest in hard assets, some don't. Differential treatment is throughout the federal and the state tax code. What that case actually stands for, the Caterpillar case stands for the fact that the Water's Edge method is not discriminatory in a constitutional sense. The assertion was made, common sense, that broadening the base will result in increasing tax revenue. The Commission dug into this and found that this is false. It is not. It is a flawed assumption to presume that when you expand the tax base, you're going to get more tax revenue. So let me try to explain this briefly. In separate filing, each corporate entity files their own tax return. In combined reporting, which we have adopted to the Water's Edge, all activities across the 50 states are combined into a single return. This is why New Hampshire uses this very curious formulary apportionment. So when we talk about the change the legislature made a couple of years ago from 3-factor to single sales factor, we're talking about an arcane methodology for expanding the base out to the Water's Edge, out to the 50 states, and then allocating it back based on sales factor to New Hampshire. So if you eliminate the Water's Edge limitation and apply combined reporting worldwide, yes, you dramatically expand the base. All of a sudden it becomes relevant what Shell Oil made in Britain, what they earned in Netherlands, what they earned in Indonesia, et cetera, et cetera, et cetera. But just imagine as that denominator mushrooms out, New Hampshire becomes infinitesimally smaller. So just consider this fact. We are about 0.34% of the economy of the United States. Right, there's 50 states and we're a small one. So it's 1/3%. And so even when we apply Water's Edge, if you've got a company that's doing business in 50 states, you might just say more or less roughly, they're going to allocate only 0.34% of that business activity to New Hampshire. That, of course, is going to vary very much on where they're based and how they're doing business. But it does not necessarily generate more income because you expand the base and you contract the numerator, and you may end up in the same place or even worse than where you were. I hate to labor through that, but the reason you needed a commission and the reason you got a report is because this is complicated. Final comment. What the federal government does in the so-called separate filing system is they deploy a methodology called arm's length. And they have a elaborate set of regulations that give them the ability to insist that a foreign company that is using transfer pricing use reasonable prices. And in the audit process, if they find that a corporation has been making transfer payments that are not as two different entities at arm's length would do, like two unaffiliated corporations in a contractual relationship would do, then their regulations give them the authority to correct it, to insist in a revised tax return and to enforce the law. New Hampshire gets the benefit out of that activity. So the Conoco case that was cited is an example of that. The reason that that was in the court was because it was an enforcement action to insist that arm's length pricing adjustments be made. It's actually an example of getting into the specific tax return of a specific tax filer and correcting it. So the assertion that there are two tiers of taxation is just not valid. There may be different outcomes. There may be different circumstances. Some companies may make certain transfers and some may even abuse them. But the idea that our system is fundamentally set up so that there's two tiers is just not supportable.
Thank you, Representative Spilsbury, and thank you for all the work you've done in this commission and the deep dive that you've done there. Representative Platt.
Yes, I did not understand one thing you said, Representative Spilsbury. I'll use an example, hypothetical. Let's say a business is doing $1 million of sales in New Hampshire, and they're doing 500 million nationwide. So there'd be 1 million over 500 million times the tax burden that would come out, Water's Edge. If you go to worldwide, you still have the 1 million New Hampshire, but you might have 3 billion internationally. So it's much, but that percentage would be therefore much reduced, and you don't wind up necessarily with more tax. Is that correct? The one thing you said was
that is precisely correct, because as you expand the tax base, you dilute the numerator and you end up with something that is no greater because you have a smaller share of a larger pool.
You said reduce the numerator. That I did not accept, but it's diluted because you have a bigger base.
The denominator grows, the numerator shrinks, and so the fraction becomes dramatically smaller.
I didn't understand how the numerator shrinks because it's the same revenues in New Hampshire either way, sales in New Hampshire either way.
Yes, mathematics, and I'm thinking of the equation in two different ways, but you're right. It's the profits earned in New Hampshire divided by, under our current system, the profits earned across 50 states. And if this was implemented, it's the same numerator in terms of profits against a much larger denominator, so that the percentage of the factor is dramatically reduced.
Mr. Chairman, oh, I'm sorry.
Yes, Representative Almy.
Thank you. On the problem, because of the transfer pricing, is that the profits that you're talking about on are reduced artificially because Microsoft or Amazon, which are two of the ones that play with this in this field, have sent their intellectual property at a reduced rate to their subsidiary in Ireland or the Virgin Islands or wherever, where there is a 0.5% tax. And that has reduced their profits everywhere else. And that is an issue which is they are trying to work on, especially in Europe and some other countries, not so much in the United States. And I believe that is partly because the IRS for years has been starved of revenue, of money, and has had to reduce a lot of what it was doing, especially going after very wealthy corporations that it requires a lot of money to go after. They are now starting to do that. They may start working on this, but because that is a major issue, and because we have just, against the will of both sides of our committee, moved to a system that starts this next year, I believe, or maybe it started this year, actually. We'll see it next year. Single sales factor based only on sales in a state with an elderly population and a lot of businesses that specialize in selling outside the state instead of inside the state. We are going to be in a considerable amount of trouble. And I want to keep every idea, even if they aren't fully developed yet, that might help us to survive that alive. So I'm going to be voting against the ITL. Thank you.
Representative Spilsbury.
Yeah, I think much of what Representative Almy has just said is valid, but it doesn't change my conclusion. You've just zeroed in again on the single sales factor, and I am actually a little concerned as I think quietly listening to the exchange I had with Representative Plett. I want to be more clear. Where you have three factors, what you do is you take that mix, right, of assets and employment and sales. So we're now moving into single sales factor. Let's focus on that. What you basically are asking them to do is to measure their sales in New Hampshire. That's the numerator, not the profits. Sales in New Hampshire to the sales across the 50 states. And if we go forward with worldwide combined, to the sales worldwide. And that's the ratio that you then multiply against their worldwide profits to determine what portion of those profits are attributable to New Hampshire and subject to New Hampshire tax. So the ratio is sales activity multiplied against worldwide profits to determine the New Hampshire taxable profit.
Representative Schamberg.
Just to finish this up, when Representative Ullery was talking about all these experts that came in and gave their explanations, I appreciate that. But that is not what the legal position was by the New Hampshire Supreme Court. Okay. And in our commission, I called my good friend from Charleston. He should have been a coach, Coach Spilsbury, because at times I believe that there's some misdirection here. In contrast to what the New Hampshire Supreme Court pointed out, in the summation, the foreign multinationals were arguing about dividends and royalties, not their entire income. And it's only the U.S. multinationals that are taxed on the dividends and royalties sent over or sent back from their subsidiaries anywhere else in the world. That's what the whole case was about. And when it is said that there was no discriminatory factor, this is what they're talking about. The Supreme Court is talking about that they were not being treated any differently than any other domestic business that receives dividends and royalties, because this was value added to their company, and that had to be reported. I hope that we will eventually be able to make some positions on the floor of the House come January, which I think we would find very interesting, and try and explain to 480 or 380 other representatives what this is about. And hope you'll give us the opportunity to do that. Thank you.
Yes, Representative Elberger.
Thank you, Mr. Chairman. Representative Spilsbury pointed out that New Hampshire economy is about 1/3 of the United States economy. We have fewer than 1.5 million people here out of a total population of over 300 million, if I remember correctly. We don't have a problem saying, even so, we want a distinction such as being the first in the nation in presidential primaries, and that's great. The fact that we may be a small state with a small economy doesn't mitigate the factor that we have the right and responsibility to look at what that means. There are two issues. There's the tax revenue, and as Ways and Means Committee members, we are charged with looking at that revenue and what it will do in terms of funding our state for the coming years. As representatives, we're also charged with, I believe, we're charged with dealing with the issue of fairness, and whether that means that tax revenues might drop or increase if we switched to a non-Water's Edge way of looking at things. The issue is we need to be fair and not put our own state companies at a disadvantage in access to tax law. Sometimes the law is wrong. The country was founded on the belief that the British law was wrong and we needed to set up our own laws. Not more than 100 years ago, just over 100 years ago, women by law were not allowed to vote. We change laws as we see we need to ensure fairness and equity of access, not necessarily of outcome, but of access. And I believe that that's an equal part of what this entails, in addition to the issue of what the revenue would be. Thank you.
Thank you. Anybody else? All right.
If I can,
One representative.
I just want to be very brief. I am one of those who applauds New Hampshire's willingness to be courageous and different, and we can all come up with many examples and defend them. But we're talking about taxation. We're talking about multinational situation. We're talking about enforcement hurdles, talking about filing complications. We're talking about auditing problems. And we're going to go about this in a way that delinks us from the Internal Revenue Code. I think that's unwise. So We can choose when it's right to be different, and we can choose when it's probably not wise.
Thank you. All right, seeing no more, we will ask the clerk to take the roll.
I shall do so. This is an ITL motion. Chairman Janigian,
Yes.
Representative Ullery,
No. I mean, yes, ITL.
Representative Doucette,
Yes.
Representative Spilsbury,
Yes.
Representative Platt votes yes. Representative Nodder,
Yes.
Representative Sodi,
Yes.
Representative Ors,
Yes.
Representative Rochefort,
Yes.
Representative Almy,
No.
Representative Ames,
No.
Representative Southworth,
No.
Representative Malloy,
No.
Representative Schomburg,
No.
Representative Fellows,
No.
Representative Bolton,
No.
Representative Elberger,
No.
Representative Leapley,
No.
Representative Pratt.
Yes.
Okay, that's 10-9. One not voting.
That goes on the consent calendar, right?
Okay, close the executive session on HB 121. We'll now open the exec session on HB 192 and recognize Representative Almy.
I move ITL on House Bill 192 FN and want to speak to my motion.
All right, do I have a second? Second by Representative Doucette. Representative Almy?
Thank you. This bill was written to modify the interest and dividends tax RSA 77, but I've been changing it. But in HB 2, RSA 77 was repealed as of the end of 2024. Therefore, the full committee was unanimous in voting ITL. A new 21st century version will be heard in 2024 when the need for the tax is foregone to avoid further property tax increases will start to become evident. I obviously need to work on that a little.
Thank you. Any other comments or questions? All right, the clerk will take the roll.
To recreate a sheet sentence since I misplaced it. On the motion, HB 192 FN, motion is to ITL, Representative Janigian, Chairman Janigian,
Yes.
Representative Ullery,
Yes.
Representative Doucette,
Yes.
Representative Spilsbury,
Yes.
Representative Platt votes yes. Representative Nodder,
Yes.
Representative Sodi,
Yes.
Representative Ors,
Yes.
Representative Rochefort,
Yes.
Representative Almy, Representative Ames,
Yes.
Representative Southworth,
Yes.
Representative Malloy,
Yes.
Representative Schomburg,
Yes.
Representative Fellows,
Yes.
Representative Bolton,
Yes.
Representative Elberger,
Yes.
Representative Leapley,
Yes.
and Representative Pratt.
Yes.
The vote is 19-0, one not voting.
This we could put on. This we could put on consent unless we have an objection.
Yes, since you're killing it, yes. If you weren't, it's money.
Okay.
Oh, I see what you're saying. Okay, so it can go on consent. Okay, we'll close the exec session on 192. We'll now open the exec session on HB 569 relative to the state education property tax. Representative Ames.
I move interim study on HB 569.
Do I have a second?
Second. Oh, I just saw.
Sorry.
Okay.
Second, Representative Platt. Any discussion? Do you want to speak to your motion?
Just say a few words. This bill, as we all know, addresses the statewide education property tax and provides for its the collection and then payment of the revenues into the state level and then disbursement out for educational purposes. It also strengthens, extends, makes more generous the rebate program for property taxpayers locally whose income is low. And it is and will be, the need for it stems from constitutional law considerations. There is a case right now pending decision that will address the constitutional issue, and hopefully it will come soon. But in its absence, I believe the best method of addressing this bill is to hold it and place it into an interim study mode. And that's why I'm moving that.
Thank you. Any other questions, comments? Seeing none, the clerk will call the roll.
Thank you, Mr. Chair. Chairman Janinigian,
Yes.
Representative Ulrey,
Yes.
Representative Doucette,
Yes.
Representative Spilsbury,
Yes.
Representative Platt votes yes. Representative Nodder,
Yes.
Representative Sodi,
Yes.
Representative Ors,
Yes.
Representative Rochefort,
Yes.
Representative Army,
Almy.
Almy.
Yes.
Sorry. Are you not in the military? Sorry. Representative Ames,
Yes.
Representative Southworth,
Yes.
Representative Malloy,
Yes.
Representative Schomburg,
Yes.
Representative Fellows,
Yes.
Representative Bolton,
Yes.
Representative Elberger,
Yes.
Representative Leapley,
Yes.
and Representative Pratt.
Yes.
19-0, one not voting.
All right, if there's no objections, we'll put it on consent. All right? Put it on consent.
Mr. Chair,
Yes.
since I've been asked to record this, can I just establish who will write the report or any minority report on each of these four bills?
Yes.
So I'll assume that Spilsbury and Schamberg will write a majority and minority report for 121.
Right.
Good, okay. And Representative Doucette for SB 112. Is there a minority report?
Yes, Representative.
I'm not allowed to because I'm just a substitute.
Okay, so there's no minority report.
None, okay. Good, and then on HB 192, Representative Almy?
Yes. Yes,
Yep.
Representative Almy.
Good,
Gave you I just need to massage it a little.
That's fine.
and for HB 569, Representative Ames?
Uh, the time frame would be probably by next Monday. Is that all right? Representative Spilsbury, you'll have your report done by Monday? Okay. Okay, that concludes our work today and really the work for the year. Oh, did I not exec? We'll end the exec session if I didn't end it on the 569. But this concludes our work for this year, and we'll see you all next year. Probably January 3rd, I guess, is our first host session. So,
To give a
Yes.
special thanks to our chair, acting chair, Representative Janigian, who's stepped into this role unexpectedly and has managed it superbly. So
thank you very much. Appreciate it. Thank you.